I'm not sure if number 602-770-3166 is a presenter. If you are, that's great, but if not, you might want to mute yourself so that we can't hear the background noise.
I will mute everyone to make sure that we can hear our participant as he comes in.
Great, thank you.
For all of those that are on mute, we're just waiting for our presenter to arrive and others to join. We have a lot of folks that have signed up. For anyone that's having trouble with their audio, in the group chat, I pasted in phone numbers if you need to call in on a telephone to hear if your computer audio is not working. Is everyone able to hear the audio? Good.
Yeah.
Hold on, someone is having a hard time. So let me go ahead and send it to them. Our presenter was having issues, so it'll be a moment. I hope everyone's enduring these quarantine times. I am forwarding to some folks that are having trouble, so it'll be a moment.
Hello.
Hello. We're just holding, our host is having a hard, not our host, our presenter.
No worries.
Aren't there always technical difficulties? It's only our presenter, so anyway. Let me go try to assist him. I will be right back. Okay, I resent him his confirmation email. Slides will be shared. And they'll be loaded up on our website as well. So as soon as our presenter is on, we will begin. Let me. Okay, it looks like Josh is on, or getting on now, so hopefully his sound will work. Okay, there he is. Welcome, Josh. I bet he's calling in on his phone. During the presentation, if you have questions, put it in the chat. I'll be monitoring the chat room and then periodically asking questions of Josh. And then we'll also have some interactive polls to see if the information that we're sharing makes sense. Josh, when you're ready, if you share, you'll take over the primary part of the screen. I am going to check on him. Hold on a sec. Okay, again, we're still waiting on our presenter. He was having technical difficulties. It looks like his video is on. Now he's connecting his audio, and then he will share his presentation.
Can you
Okay,
all
Josh.
hear me now?
Yes, we can hear you.
Okay. Okay, let me. Okay. Okay, Laura, you there?
Yes, I'm here. We can
You're
see
ready
your
to get
screen.
going?
Mm-hmm.
Yeah. Okay. Okay. So should we get started, do you think?
Yes.
Okay.
I want to welcome Josh Moselle, who is a president of ACMI, the Association for the Chronically Mentally Ill, and tonight he's going to provide an educational session on involuntary treatment.
Okay. Thanks, Laura. And sorry for making everybody wait. We did run throughs, believe it or not, to try to troubleshoot, and then all the trouble came right before we got on. So anyway, thanks for joining us. Hopefully the technology holds up for the presentation on civil commitment. Before we get started, my name is Josh Moselle. I'm an attorney here in town. I'm the president of the Association for Chronically Mentally Ill. Just a quick comment about ACME. It was formed a few years ago, maybe 3 years ago, by parents who had kids who have just cycled through all the different systems that you do when you're chronically mentally ill: jail system, criminal justice system, emergency room departments, civil commitment process, living on the streets, all of that, constant interactions with police and fire. So it's founded by a group of parents who wanted to try to interrupt that cycle somehow. I graciously was added to that group, and so we've been doing things ever since. This presentation on civil commitment fits into our mission like a glove. Our population that we focus on is the sickest portion of the SMI population. So we think about 5% of the 25,000 people diagnosed with a severe mental illness or serious mental illness in Maricopa County are chronically mentally ill. That's the population we focus on. We also very narrowly focus on the outcomes that we want, which is more housing, more permanent supportive housing for that group of people, and looking to identify gaps in the continuum of care and try to improve those, because there's lots of them. So last year we worked on creating a secured residential and got that passed through the legislative process. So that's ACME. Civil commitment fits in very well with what we try to do, because everybody in that 5%, this is kind of part and parcel to their treatment. Unfortunately, they have to go through this process and oftentimes go through it many, many times. And so the goal of tonight is to provide some education on the process. Hopefully, you guys will have a better understanding of the legal underpinnings, the way the process works, some context for things that go on. And if the process is ever needed, you'll be able to better get through that process. So I think the best way to start, and we have a bunch of information on ACME, just kind of our mission statement. I'm not going to go through it, but anybody that wants to read it, of course, please do. When we're talking about civil commitment, I think the thing that we need to do first is take a step back and understand what's really going on. And what's going on is the government is stepping in, the state is stepping in and taking away fundamental rights. And anytime that happens, there needs to be a lot of protections in place. And so the most famous federal case is called O'Connor versus Donaldson, and it described when rights can be taken away. The case Addison versus Texas described what the legal standard is for taking away those rights. So those are kind of the preeminent federal cases. Within the presentation, I provided Arizona statutes or Arizona case law. And the first three, I think, are when I think about writing something, these are the three that I go to, because they really talk about just what civil commitment is, which is a massive curtailment of liberty. When somebody goes through the process, they get taken away from their home, they get picked up by police, they go to a hospital and receive treatment against their will. Their clothes get taken away. So it is a massive taking of liberty. And because that's the case, there has to be lots and lots of due process protections. That's the first case listed. When that happens, the statutes must also be narrowly construed. And anything that happens in the process must be strictly adherent to the statutes, kind of showing that's part and parcel to the due process provided, is that we have laws and we know what's going to happen if we get picked up, and those things must be followed. So there's a bunch of other cases, talks about who can be a witness, why we don't want doctors to be the only witnesses, things like that. But feel free to browse through those. If you have any questions, you can always email me. The place that civil commitment law comes from our statutes is Title 36. So lawyers typically call civil commitment or the petitioning process Title 36. And so within Chapter 5, it goes through the whole thing. The Administrative Code, Title 9, Chapter 21, kind of colors in the lines and provides some more information about it. But that's where the law emanates from. And all civil commitment processes are the creation of state law. So one question I get commonly is, my son or daughter is ordered into treatment in Arizona, but we want to move to New York. Is this order going to be in place? And the answer is no, it's not. Once you cross the border, it has no authority whatsoever. And so it's a creation of state law, and in Arizona, it's found in Title 36. With respect to the standards, how can somebody be picked up for this? Every state has dangerousness standards. Every state has danger to self, danger to others. And those things are that there's an imminent risk of severe physical harm to yourself by some action that you're going to take, or imminent physical harm to someone else. Every state has those. We also have something called gravely disabled, which every state has some kind of variation of that. That means that you're so disabled by the disease that you can't take care of your basic needs, your medical conditions, your financial situation. You can't take care of anything in your life.
Hey, Josh, we do have a
Sure.
question.
Okay.
Are there any new statutes in the pipeline that we should be aware of?
Currently, there's not. So over the past few years, there's been lots of talk about it. And mainly the reason is the statutes are confusing. And I'm going to get into why they're confusing later, but they need clarification. Besides that, I think we have a pretty good system, a pretty fair system. And I think our laws are better than most states. And so at this point, there's not any major reforms thought of. This last year, the one thing that I remember coming up was police didn't want to have to provide service during the process, something very minor. But there's nothing in the pipeline now. I'm hoping that we can at least clarify, though, because as we get into it, you'll see how confusing they can get. So
one more question too, is persistently and acutely disabled the same as gravely disabled?
no.
And I think you're going to go to that now.
Yeah. So, like I said, every state has dangerousness standards and some variation of gravely disabled. PAD, basically, and I put the statutory language there, but it's long. What it boils down to is somebody has a severe mental illness. They're likely to suffer severe emotional, mental, or physical harm. They would benefit from treatment, but they don't understand the need for treatment. And so it's a much different standard than the dangerousness standard. So, for example, I have a friend in Washington who runs an advocacy group, and she started it because her son is very mentally ill and constantly on the brink, inside of a crisis. He threatened suicide. That didn't work. She filed a petition. It wouldn't work. He'd do all kinds of weird things, take his clothes off in public, wander down the streets. Her petitions were never approved. It wasn't until he jumped off a bridge and survived jumping off a bridge that he was finally civilly committed. Most states don't have what we have, which is a need for treatment standard. And that's what PAD is. It allows you to step in before the crisis, before the fifth jail visit, before the person ruins all of their relationships because of the enduring psychosis, before the psychosis changed the brain. So in that way, we have pretty progressive laws and laws to protect those who are just getting into a crisis. And I'll talk about one case where we made mistakes and the consequences were dire. And so to get into the process, you got to meet one of those four standards: danger, self-danger, others, gravely disabled, or PAD. And the person has to be unwilling or unable to participate in treatment. When those two things are combined, then an application is warranted. So wanted to go through some common scenarios that I deal with all the time. And I think, Lori, you're going to try to do a poll, at least on the third one.
I think we'll have to ask. I think it's going to be difficult because it's telling me since I have more than one login, I can't do it. So I think.
Okay. Well, I'll go through these and then I'll circle back to them. So these are things that are very common that come into my office on a regular basis. The first one is somebody calls about his 22-year-old daughter. Jenny, she's been saying she does not want to live any longer, wishes to get run over and die. She does not have a suicide plan, but has means and has never taken any suicidal action. So that's the first scenario. In that scenario, because there's not any imminent risk, if you filed a petition on that, they're going to kick it out. What they would say is there's a death wish, but there's no imminent action or behavior that requires hospitalization, and so that's not making it through. And so it's got to be more than that. And if you move to number 2, you can see what more it needs to be. Same thing, Jenny, 22 years old, called home and she said she's going to kill herself. She has a plan to take pills and has access to pills. So that situation, because she's threatening imminent harm, an emergency petition could be filed and she would be picked up pretty quickly under danger to self. Third one is kind of questioning danger to others. Client calls to tell you his son finished at the top of his class at ASU, but is now living on the streets and is addicted to meth. Son is delusional and when using is assaultive. So this is kind of it depends. But what the statute says is that in order to civilly commit anybody on these standards, their behaviors must be the result of a mental illness. And so here, if the meth is the cause of the psychosis and the assaultive behavior, even though the result is the same, the manifestation is the same, this person can't be civilly committed. Be the same thing as somebody who has significant Alzheimer's and gets assaultive. That person can't be civilly committed because the behaviors are not the result of a mental disorder. One caveat to that is oftentimes people have both. They have a severe mental disorder and then they also use substances. So they go into the hospital, they test positive. Typically they're kicked out, even though the symptoms might be the cause of the behaviors. And that's a problem, and we'll talk about it a little bit later. Okay, so this is long, I'm gonna go through real quick. 33-year-old guy, he's married, has 2 kids, he's an executive, but then he started to believe that his company was involved in a conspiracy and they planted devices in his computer, iPhone, in his home and in his brain. He confronted his superiors. He was fired because his wife was also involved in the conspiracy. He's filing for divorce. He refused to live at home because of the monitoring devices, so he's living on the streets under a bridge. He made no threats to harm himself or anyone else. His family has offered him treatment, but he refuses, saying there's nothing wrong with him. So here, there's no danger to self. There's no danger to others. But if you go through PAD, does this person have a severe mental disorder? I think based upon his delusional system, you could probably say that. Is he likely to suffer harm, severe physical, emotional harm, physical, emotional, mental harm? He has. He's lost his job. He's losing his marriage. He's lost his home. He's living on the streets. All those things are present. He'd benefit from treatment. Arguably, someone that psychotic could benefit from treatment. And he doesn't understand the need for treatment. And that's evidenced by him saying there's nothing wrong with me. So this person could be civilly committed and should be civilly committed. And this was a case of mine, and we got him civilly committed, and his life is back on track. But commonly, these kinds of things don't make it through the process. The PADs are much more difficult to get through. And so understanding the underpinnings, and we'll get to them a little later, is really, really important if you're trying to get someone treatment when they don't have danger to self, danger to others behaviors. So stop for questions. Any questions up until this point?
I'm monitoring the chat. I'm not seeing any new ones come in.
Okay. Well, stop me if something comes up. Okay.
Oh, wait.
So now we're getting.
How long could a PAD petition take?
Okay, good question. And I'm going to get into it, but let me just answer it quickly. What the statute says is that you file an application, a non-emergent application, and all of the investigation that's included in what they call the pre-petition screening has to get done within 2 days. It's a pretty bright line rule. There's really no way around it. But what happens is weeks and weeks go by oftentimes before the person gets talked to, before the investigation gets done, and before the pre-petition screening agency gets back to the screening agency so that a petition can be filed. And so I've had cases, again, this has to take 2 days. I've had cases that take 20 days, 30 days, 42 days for things to happen. And when somebody is so psychotic that they're walking around the streets without much clothes on, they're losing their house and home, they're spending all their money, there's not time to do that. And that's why the statutes are very, very clear about the timelines, and it needs to be done quickly. Despite that fact, the system just doesn't process things in that way. And we'll get into it and things we might be able to do to change that. But they can take a very long time. I would say on average, they take weeks, and they should take days.
Josh,
By
we have
law.
another question. Is there a move to change the definition of mental disorder? And I assume that means in the state, not nationwide.
Yeah, there's been lots. Yeah, there's been talk to clarify the definition, to make it clear that somebody who has a mental illness, but also has a positive drug screen, for example, shouldn't be kicked out just because they have the positive drug screen. And that's one of the biggest problems in the system, is that things like that knock people out. And so the definition, really, we haven't thought about changing, what makes up a mental disorder, just clarifying the procedures that take hold when somebody gets in. Now, I think related to that is whether or not somebody can be civilly committed for substance abuse. There are states that do that. If you go to court and you prove that the person can't make reasonable decisions because of their substance abuse disorder, and they're putting themselves in harm's way, that person can be civilly committed to substance abuse treatment. So I work with Florida a lot for that very reason. People going out to Florida can be civilly committed for substance abuse disorders. Can't happen here. And there they basically are given a choice. You go into treatment or you go to jail. So there has been discussion here about adding that to one of the criteria that can lead to civil commitment. There's all kinds of issues with that, but there is movements there, and I think we can see that coming up in the very near future. Probably next year, that's going to be a topic.
Josh, it appears that in Florida, especially, that they have a lot of drug treatment, and a lot of them have been not the greatest. There's been a lot of bad practices exposed. So how would we protect our state, our people, from just feeding into this big industrial complex of drug rehab that's so expensive and often not well monitored for good outcomes and good intentions?
Yeah, well, that goes on here too, Lori. I mean, I tour a lot of substance abuse facilities. There's not many that do a great job, and so that's already here. My concern with adding substance abuse to civil commitment is we already have an overloaded system. We already have a system that really doesn't have capacity at certain places for the severely mentally ill or those who are being civilly committed. And so if we're also pulling in a big population of substance abuse, people that have substance abuse disorders, I think we're going to create problems. One, on the capacity level, and then two, the treatment course is completely different. And so the resourcing, I think, is a big problem and needs to be thought about before. So while I think there's good arguments for adding substance abuse to a criteria to civilly commit. There's all kinds of logistical problems that I think need to be worked out first.
Okay. I don't see any other questions at this point. We may want to move on and get
Okay.
questions, because this, I think it will head into
Okay.
some territory that will probably prompt some questions.
Okay. All right. So if you look at the slides, I just included some acronyms that people use in the system, sometimes appropriately, sometimes not, but they're there for you. Okay. When I started doing these cases, and I started doing these cases when people would call me and they'd say, I'm locked up in a hospital, I have been for 10 days. Can they do this to me? I'd never done one of those cases. And so I started reading the statutes. They were completely indecipherable to me until I realized there's really two different processes. There's an emergent process and there's a non-emergent process. And when you view it in light of that, then you can see the intent, you can see the pathways. And I created a flow chart that has all the steps and all the law in each one. And so for the first three big stages, they're separate. They come together once there's an order for evaluation. But until that point, they're very, very separate. And the dividing line is if the person, as a result of their mental disorder, needs immediate hospitalization or they're going to suffer severe harm, then that's an emergency. That's the way that the statute divides between emergency and non-emergency. So how do you start an emergency petition? And again, this is going to be danger to self, danger to others. It's not going to be PAD. It's not going to be gravely disabled, because those conditions are not going to need immediate hospitalization. Gravely disabled might, but it would be very rare. So you go into one of these three facilities. There's three in Maricopa County. There's one in downtown Phoenix called UPC. There's one in the East Valley in Mesa called CPEC. And then there's one on the west side called RI International. So you need to go to one of those three facilities and file what's called a petition, which isn't the right legal word, but that's what everybody calls it. If you walk in and say, I need to file a petition, they'll know what you're doing. They also use the term AB forms because they're asking you to fill out two forms and they have an A and a B on them. So within those forms, you need to explain the immediate risk, the actual statements or behaviors that led to that risk. They'll ask you for some history that supports the concerns. Really, I don't think that's completely necessary. There's lots of situations where there isn't history. Why the person's believed to be unable. So typically that's that they have told you, I'm not going to receive treatment, or told their doctor. They're too psychotic to make decisions or to consent. They've left some other treatment facility against medical advice. And then the last part is why it's believed they have a behavioral health disorder. And that typically comes from some kind of previous diagnosis or an SMI determination or a hospital stay, or the prescription of something like Haldol, which is a medication for psychotic symptoms. And so you have to demonstrate that the person has a mental disorder, they're unwilling to seek treatment, and there is an immediate risk.
We had
That's
a question
all.
too,
Yep.
Josh. Does someone have to be related to the person to fill out a petition?
No. Person has to be an adult, 18 or over, and they have to be what the statute calls a responsible. Any responsible person can file. And so really, any adult is able to file these forms. That also includes police officers who will show up to a scene, see behavior. But a few years ago, the statute was changed. The police also had to have firsthand knowledge. So that's one other piece that I was going to touch on, is to file an emergent, you have to have witnessed the behavior firsthand. Police, until a few years ago, the statute said that they had to have firsthand knowledge. Now they don't, and so they can pick up and take on in if they have probable cause to believe that the person's likely to need hospitalization, immediate hospitalization. So that's one other way to get your foot in the door, rather than going down to the place. If it gets so bad that police need to be called, police can do it, and they don't even have to see the behavior. They can take your word for the behavior. And so to circle back real quick to your question, Lori, no, you don't have to be a family member or a friend to do it. So quick nuts and bolts, got to be adult, got to have firsthand knowledge. They're going to ask you to put in a second witness when you fill out the form. They'll reject applications if you don't have that. That's not based on any law. There's actually case law that says they can't do that, but they're going to ask for it. So you kind of just got to play by their rules. Then you're going to have to describe the person, the way they look, if they have any tattoos, their eye color, their height, and then where they're located. That's for the purposes of the police pickup order, which is issued. Police then go into the community and pick somebody up.
Josh, one question on that last one.
Yep.
2 questions. One, does the behavior need to be witnessed within the last 24 hours? That was our experience, that if it was longer than 24 hours, they would kind of, it's no longer an emergency. So what is the law around that?
Yeah, so there's lots of things within that process that people get told, and then you might ask why, and the answer is, well, that's just the way we do it. But the 24-hour rejection of applications is not based in any law. There's no time frame for the behavior. What it says is that the person must be at imminent risk. So as you go back in time, let's say that the person threatened to kill themselves 2 days ago, but a day passes, another day passes, and a week later you file the petition. The provider at the facility is going to say, well, yeah, she said she was going to kill herself, but that was a week ago, and I don't feel like we need immediate hospitalization. So that makes sense, but that's different based upon all the situations. For example, I had a case where a guy was saying that he was going to kill himself when he turned 20. And so he went and bought a gun, and he watched a bunch of videos about how to make sure that he was effective. That's somebody that around a certain date is going to be very dangerous to themselves. And so all the facts and circumstances need to be taken into place. Comment to take a step back. This system is very overloaded. And for a variety of reasons, it's going to look for ways to screen out rather than screen in. And one of those ways is little rules like, well, it has to have happened within the last 24 hours. That is just not based in law. We're going to talk about another one with substance abuse. That's another way that they screen out. But the system is overloaded, like a lot of our public systems. And so you can't always trust the front line to give you accurate information about the way the process works, which is why all that stuff, if somebody's going to go through this process, they need to be tracking and documenting everything that happens. And we'll talk about that in a little bit.
Josh, we have another question.
Okay.
A CIT officer, police officer, will they need only one to witness it, or with firsthand, or could they just use the knowledge? Or does it need to be more than one seen by the police? I thought I heard that police don't need to see it, right?
Well, yeah, so police don't need firsthand knowledge, and they don't have to have a witness to bring somebody in. So the whole witness thing, 2 witnesses are required at the hearing. they're not required for this kind of gateway process to the court hearing. But again, like the 24-hour, the behavior has to happen within the last 24 hours. This is another misnomer, that if you don't fill out the witness form, you're not going to get your petition through. It's not based in any law. The witnesses come into play at the hearing stage, which is a couple weeks down the road, but still you have to have them. Cops are a different story, though. Cops don't have to have a second person witness and put on the form. Does that answer your question?
I think so. Thank you.
Okay. Okay. So on the emergency process, though, I have a flow chart that includes all the relevant statutes. And so as far as timelines go, this is how it works. Petition is filed, pickup order gets issued. Police go out, they put somebody in handcuffs, they bring them in to the screening agency. And the screening agency has 24 hours to determine if they're going to keep the person and file a petition for court-ordered evaluation. You can see above the red box, that's where that gets filed. So 24 hours, they file a petition. That starts the evaluation period. In that evaluation period, two psychiatrists have to go and evaluate the person independently, and they each have to reach the conclusion that yes, they meet the standard for civil commitment. And once that happens, they file a petition for court-ordered treatment, and that's described above the green box. Then there's a 6-day period between the filing of the petition and your court hearing. During that time, oftentimes people change to voluntary status. The doctor believes that they're able to follow through on treatment, and so they get released. They also can be, during that 6 days, they can go home and just come back to the hearing 6 days later. That almost never happens. They can get a doctor, a psychiatrist appointed to them. And then at that 6-day point, they go to hearing, and the county tries to prove the case and reach that clear and convincing standard described in Addington. So that's the emergency process. So people always ask, well, where's the person going to be during this 96-hour period? So the law says one thing, the way it plays out is another. The law says that during this red period, they got to be at an evaluation agency, which is Valleywise or the old Desert Vista. But the way it happens is the screening agencies, those 3 hospitals I described before, and Desert Vista share this 96-hour period. And so somewhere along the line in the 72 hours, they're going to get transferred over to Desert Vista, where the remainder of the time will run, and then they file the petition for court-ordered treatment, or if they don't, the person gets discharged. And so they're going to be in one of those 2 places, a screening agency or at Desert Vista or Valleywise for that 72-hour period. Okay, the non-emergent process. This is where PAD comes into play. To start that process, rather than going straight to the hospital, one of those 3 hospitals like we described before, you call the impact line, the PAD line. I put the phone number and the extension up there. But this is something I had problems with a few years ago, which was the statute again says that, the timelines here, they've got 48 hours to get all of this done. And so you'd call, and what happens is you leave a message, and I've never had it picked up. They then call you back and they schedule an appointment, and that takes a few days, and then they go and do an investigation, and that takes a few days. They try to meet with the person even though they don't have to. And so it extended the timelines by weeks. 3 or 4 years ago, they changed this to this no wrong door policy, which allows you to walk into one of those 3 hospitals just like you would on an emergent and file a Form A, file the PAD application, which makes it a lot easier. It sets the time frames better. And so whenever I'm talking to clients about the way to do it, I don't even call impact anymore. It's not going to get you the relief as fast as you might want. And there's considerable delays. Not that there aren't delays with the other way, but there's not the same amount of them. So on the Form B, which I put, or the Form A, sorry, I put Form B, but the Form A, I included it here. You describe the PAD behavior. And again, PAD boils down to 4 things: severe mental disorder, severe mental, emotional, or physical harm, can't provide informed consent, and can be made better by treatment. Those 4 things. So if you look at the form, it's almost hilarious the way that it doesn't ask those questions. It doesn't ask about the reasonable prospect of being treated at all. And that's an important fact. If somebody's going to be civilly committed, that's other case law that you if you're going to be locked up, you have to be able to benefit from the treatment that they're going to give you. That's not even asked here. The harm, which is the hardest part to describe, that's not asked about. The closest thing that it gets to is the person's dangerous or disabled. Those are very different things than severe harm, physical, emotional, mental harm. Somebody could be spending all of their money or divorcing their wife, that they're not dangerous and they're not disabled. And so it doesn't ask the right questions at all. And so it creates tons of confusion. I've talked to the lawyers for Access and ADH, and I've told them, I will help you redo the form for free. They've never taken me up on that offer, but it creates a lot of confusion. And so the thing that you have to focus on with that application, if you're going to get it done right, is the harm section. And you have to fit it in where you can. Typically the best place is in number 4. But the severe mental disorder, that's typically obvious on its face. And I'm going through the 4 elements of mental disorder, or of PAD right now. Can't provide informed consent. Typically they're denying treatment. That's pretty easy. Can be made better by treatment. There's a history of it, or typically somebody that is very, very psychotic can be made better by medications pretty darn quickly. Those ones are pretty straightforward and easy. It's the harm that has to be described that trips people up. The harm here is not imminent danger to yourself, like putting a knife to your throat, or walking to jump off a bridge. It's not that. It's not imminent threat to somebody else. It's not pointing a gun at somebody or attacking them. That's not the harm that has to be, that's not the burden that has to be met here. And I put a few examples. It's things like not taking care of your medical needs. Last week I had a case where a guy, diabetic guy, believes that he's God, and God doesn't need to take insulin. Therefore, he stopped taking insulin, and his blood sugars were off the charts. I mean, he was close to lots of serious medical conditions. People, when they're psychotic, go out and they commit petty crimes, do stupid things, but they end up in jail for those things, and those things stack up, and they end up in real trouble. Had a guy who went out and spent $28,000 on Suns tickets when he got manic. Losing your job, filing for divorce because your wife is in the CIA. Those are the kinds of harms that are contemplated under this standard, and those need to be listed clearly. And I guess one other point is you can always attach a page if you run out of room on those applications. But that's the hardest part of the PAD, is describing what the harm is, in a way that's not overtly dangerous, because that would be danger to self or danger to others. Okay.
We have a question. Who is the best resource to help complete the form? And do the people at the screening agencies help and assist families where it may be the first psychotic break and the family is not sure what they're dealing with?
Yeah, good question. And there's a long cynical answer to it. So the statute says that when you're filling out these applications, the screening agencies shall assist the person in filling out the application. So they do that, but the last time I went, the way the guy assisted was by, after we completed the application in blue ink, he came and told us, this is going to be rejected. You got to fill it out in black ink. And we asked some other questions about, what do you think about this? There's no help to be had. People cannot expect to go to the screening agencies and get assistance on these applications. They just won't. And oftentimes they're going to get information like, well, if the behavior hasn't happened in the last 24 hours, then you can't file. If the person's using substances, then you can't file. I'm trying to think of others. Those kind of things are the things that come up constantly, which aren't true and are barriers to treatment. Now, I don't think those people are lying, but that frontline staff oftentimes isn't trained on what the law says, and there's lots and lots of turnover in those positions, and so it's hard to keep them trained. And so the source to get help on what to fill out is not the screening agencies. Getting help, that's a more difficult question to answer. So, I think Acme will be putting up some information on the language that needs to be included. You can always call me, Andy Arnowitz, and maybe we can link to these things. Andy Arnowitz is always a great help. But I guess the answer is, Lori, unfortunately, there's not a great place to go and get information on it, and Acme should probably do it. So we'll put some stuff on our website to help people fill out the applications.
Maybe we could do some case examples for PAD, for danger to self, danger to others, several for PAD. I know that one thing they used to tell us for our loved one, even though he had a rich history of not following treatment or running away from treatment, when he'd get down to a screening agency or they'd amend him, he'd say, "Oh no, I volunteer. I'm just having communication difficulties with my team. I want help," which was totally a lie. And it would depend on who you were interacting with, whether they would discharge or whether they would look further into it. We do have a question, someone saying, so basically if the application is filled out wrong, that could be a deny, correct?
Oh, absolutely. Yeah, if it doesn't have the information to convince the doctor or the provider that's reviewing it that the person meets the standard, then yeah. I mean, I don't have the numbers, but people try 5-10 times to get their applications through, and they're rejected. So that's a very common occurrence.
Another question is, or just some clarification, some help that came from Barb Honenberg. Remember when filling out the forms that you have to write, when you have to write more, do it on a separate piece of paper. They will not accept form A or B if anything is written on the back. So it seems like they nitpick at small issues when maybe someone's life is at stake.
Yeah, and I mean that one actually makes sense to me, because these are legal documents and they don't want to have to, they're faxing them, they're copying them, they don't want to have to do that. So, but they should tell you that on the front end, and they don't.
Another question. Can NAMI help? Yes, Andy has been a valid source passed to those seeking help. So does NAMI help fill out forms or help get someone through the petition process?
I don't think so. NAMI as an organization, I don't think they do that, but I know a lot of family members in NAMI who have experience with it and can provide help. That's what I would do, is try to reach out to somebody in NAMI that has gone through it. But the organization, I haven't really seen much on civil commitment from them.
And we had another question: is COT the same as court-ordered hospitalization?
Kind of. One result from a court order is that you are ordered into an inpatient stay for a period of time determined by the doctors at that facility. So yeah, it's part of it, but then there's other parts of it as well.
And we had another comment. Someone went to UPC, turned in a petition, got it notarized, date stamped, and they would not give the person filing the petition a copy of it, stating it was a HIPAA violation. So they denied the application, could not even get a copy of the original application. It is not a HIPAA violation to get a copy of a form you filled out, right? Correct?
Yeah, correct. And it's a legal filing that you are making, that the person's making. And so that's a request I think should always be made. And let me just skip to something that has to happen. So there's breakdowns in the system at all different stages. And the only way to try to correct those things is by having information about it, is providing some oversight. And so anytime that one of my clients goes through the process, I track it. Everything that happens, I track it. This was a PAD. And so what the statute would say is this stuff has got to get done in 2 days. And so my client calls, PAD line, doesn't get back to him for a few days. In the end, it took 23 days. And again, I've had ones that have taken over 40. And so all of the things that happen at the screening agencies, you really got to document them. If somebody tells you, if you ask for a copy of the legal document that you're signing, that they're notarizing, you are allowed to have a copy of that. If they don't give it to you, it needs to be documented. And I would keep a little spreadsheet of everything that happens, just so you can go back. And in the end, if it's done wrong, the system can be pressed. And the only way the system starts to change is if there's enough data, information, and pressure to adjust the way that it does things. And so all those little quirks need to be documented. To answer the question, no, they can't withhold that document from you. Your legal document that you're filling out, they can't withhold it from you. So I have a picture of Jared Loeffner here. After Jared Loeffner did what he did, all the experts said there was nothing that we could do. He
For
wasn't.
those that don't know Jared, he was the gentleman in Tucson that was PAD, and it resulted in a tragedy.
And he killed 6 people, and he shot 13 others. But before that happened, he was so psychotic, he making statements that were scaring his classmates, his teachers. He got kicked out of school. School administration said he has to go to a counselor before he can come back. He went back on campus, was putting videos on YouTube with obvious psychotic behavior. He shaved his head. The morning that he went and did the shooting, he was stopped by a police officer who said he was acting incredibly bizarrely. He was acting so bizarrely that the person at the first Walmart he went to wouldn't sell him ammunition. But up until that point, he had done nothing dangerous, no DTO, no DTS. He couldn't have been petitioned on that standard. But he meets the standard for PAD squarely. And for me, the biggest takeaway from that was that there's such a lack of education, even amongst PhDs at U of A who do this stuff, about this standard and the ability to pull somebody in treatment before something horrible happens. That's another thing you're going to find at a lot of places with treatment providers, police, um, even very educated people with lots of initials behind their name. So tracking your petition, I think it's vital. If you want to push back at all, you've got to be able to do that, because they're going to provide you no help in doing it. And I have a little spreadsheet, but here, I mean, all I do is date, action, days since there was contact. Substance abuse is another significant knockout. So what the law says is that danger to self, danger to others, PAD, gravely disabled, if you're going to civilly commit somebody, it's got to be the result of a mental illness. It can't be the result of drug use. It can't be the result of dementia. It can't be the result of lack of sleep, as I wrote here. Title 36 cannot be used for those things. It can only be used when the behavior is the result of a mental illness. What happens a lot of times is severe mental illness and substance abuse are co-occurring. And so you go in, person tests positive, and they're kicked out. Really what the statutes require, and the screening agencies have a duty to do, is to make sure, not to just kick out, but to make sure that the behavior is not the result of the mental illness. They don't take that tack though, and so they push people out. And so what I do is make an attempt to explain how these behavioral health conditions persist or have persisted in the past, despite the fact that they're currently now using. Kind of notifying them before this person's going to come in and be positive, but also notifying them that I know you can't just kick out because there's a positive UA. And so putting in the application, if you know that your loved one or friend is going to test positive, explanations of times when the person was hospitalized for a couple months, couldn't have used drugs and was sober, or periods you knew they were sober, but the mental health conditions persisted, times that they were in jail, times that they were being drug tested consistently, but still remained psychotic or manic. That's the only way to get around that, because again, this is a screen out system with lots of capacity issues. They want to kick out whoever they can. And so that's one way to get around it, is first to understand that's not the way the law works. They can't just kick out without doing further investigation. And then secondly, trying to explain how this is the result of mental illness and not the result of substance abuse. Once you get through that, once there's been 2 evaluations by psychiatrists and they agree, then there's a petition for court-ordered treatment filed, and that's when that 6-day period starts. And at this point, there's lots of advocacy to be done prior to this. Once this happens, it's kind of a runaway train. There's nothing you can do for the most part to impact whether or not the person gets put on a court order or not. But it starts a process for that 6 days where they stay in the hospital, they're offered treatment, and then they go to court, and the court determines whether or not they're going to meet the standard. At the hearing, the court has 3 options. They can order you to inpatient treatment, to outpatient treatment, or a combination of both. Most typically, it's a combination of both. So the court gives the hospital the discretion to keep the person there as long as the hospital feels like is necessary. Upon release, then they get dropped into the public behavioral health system, where they have to see their psychiatrist once a month, see their case manager once a month, have a home visit once a month, take their medications as prescribed, and not get symptomatic. As long as those things are done, then the person will get through that year. If at any time those things are not done, they're going to be picked up on what's called an amendment, and it's an amendment of the court order that's in place. They amend the court order and add into it, this person needs to be picked up, and they'll be brought into the hospital, treated, given medication, stabilized. The non loophole, I just want to describe real quick. if somebody is non-SMI and they do not have access, that's called a non-Medicaid, non-SMI, then there's no outpatient provider that's going to receive reimbursement for the services. And the statute says that providers do not have to sign on. They can't be forced by the court to do it. And so if they don't get paid, they don't do it. And so what happens is if a person's a non, they get what's called an inpatient order only, which means the hospital will determine how long they need to stay. They stabilize them. The moment they walk out the door, the order expires. So it's something to be very aware of if your family member doesn't have access and it hasn't had a long history such that they've been enrolled in the SMI system.
We have a couple questions. First, can family members file the amendment, or does it have to be done by the facility, doctor, or treatment team?
Family members do not file the amendment. It's typically filed by the team that has filed what's called a letter of intent, who's overseeing the outpatient care. They're the ones that file the amendment, or the documents that would get to an amendment. Family members can't step in at that point.
One other question that came to me, let's see, if a petition has been granted and the police have attempted 3 times to bring the individual, but the individual refuses to open the door or leave the apartment and rants at the police, as heard over the phone, why do the police then drop the petition, and why does the ACT team of the clinic not follow through again?
Yeah, the reason the police don't follow through is, first, it's a civil commitment, not criminal. So they're not going to break down the door. The only time they do is if they look through the window and the person is going to kill themselves or is going to hurt somebody else. They don't do that. It's a civil commitment. Secondly, they don't last forever. So a PAD has an expiration date. It's 14 days. The emergencies are much shorter than that. And so that's all part of the due process that's involved. But that is a big problem for not only people that live alone in their own place, but then people that are homeless, because you can't find them. So in the apartment situation, the things that we typically do are try to have family reach out to them, meet them someplace, try to understand their patterns. Sometimes they'll go for a walk. And so police are pretty good about coordinating with the applicant about picking them up. Last week, I had a case where mom owned the apartment. Son had barricaded himself in, but she went over, opened the door, police went in. And if the person opens the door, typically the police are going to go in. But that's a big problem. The reason they drop it is because it's the due process involved in the process.
And a second follow-up question from the same person. If an ACT team is not permitted to enter the member's apartment and knows that the member is off their medication and is allowing homeless people to dwell with them, what is the responsibility of the ACT team to remedy this? And you might want to explain too, people that are put on ACT teams typically are people that need more guidance, right? So.
Yeah, so I think the ACT team needs to take action there, and the way that they need to do it is by filing for an amendment of the court order. But they can't, the person has tenant rights. There's only so far that they can go. If the person was in imminent danger, you might call the police and see if they'd be willing to enter. But otherwise, that's a pretty difficult situation. And besides filing for an amendment, I do not think the ACT team, I know the ACT team shouldn't be forcing their way into the apartment.
Okay, we have another one. What is the difference between having a level 1 mental health authority and an ACT team filing an amendment? I should say, what is the difference between a guardian having level 1 mental health authority and an ACT team filing an amendment?
Yeah. So I was about to get to some of the limitations of of COT. One of them is that just because a person's on COT doesn't mean that family has access to them anymore, or now is granted access to them. And in fact, sometimes the doors are locked more tightly. A guardianship with mental health authority gives the family the ability to step into the shoes of the mentally ill person and make decisions for them. So that would include, going to doctor's appointments, talking to the teams, consenting to placement, consenting to treatment, things like that. And so the level 1 authority also gives them the ability to put them into a locked hospital. Said another way, a general guardian has authority to do everything that is necessary regarding the healthcare of the ward, except one thing, which is put that person into a locked psychiatric facility. So in a guardianship process, you have to meet an additional burden, you have to have additional evidence, and then you're given that mental health authority so that they can put them in. And that would be technically a voluntary admission to a hospital. So the ward or the mentally ill person, you go to court and the court determines that the person is incapacitated to make reasonable decisions about their person. So they're no longer allowed to make that decision. Their judgment is substituted in the form of a guardian. And so the guardian would be able to consent to placement at a private hospital. Legally, it's a voluntary admission. And so the civil commitment process is only involuntary process, if that makes sense. So they're very separate things, not only in the rights of the family members, but also in the process and the hospitals that they'd be utilizing. Does that answer the question? Can you ask that person if that answers the question?
Does that answer the question? If not, can you sign it in chat? Yes, it does. One other question. We have a long one and we have another short one. Can they still petition if they do not have mental health powers?
Yes, you can't see the guardianship process and civil commitment as the same thing. They go to two separate courts. They have different authorities. They're non-concentric circles. And so anybody can file for COT, even if the person has a guardian. COT can be filed for. Even if there's COT, the person a guardianship can be filed. And so they're very different legal mechanisms. Oftentimes they work together, and oftentimes they're necessary. Because like I was saying, COT drops you into a mental health system that doesn't always work very well, but the family's boxed out of that. And so the person goes to their doctor and the doctor says, "How's your medication working?" The person says, "It's great." But the family knows that they're actually backsliding, they're getting worse. That information needs to be conveyed. But if it's just a COT, they don't have the ability to do that. A guardian can come in and augment that and make sure that the treatment provided is as good, and the information provided to the doctors and treatment team is as accurate as possible. And so there's separate legal mechanisms that really shouldn't be mixed up in your mind. They're non-concentric circles.
We have kind of two other questions. One, someone that's emailed, they've been on both sides of the process, and once it did go to a COT hearing. I was a rare person that did not have to do COT. It's very hard. It has its own trauma. There is a need for sure, but I would urge and hope that anyone considering would consider this as a last resort. Before I ask the question, I can say as someone that's been through it, of course, no one wants to do this. It is a last resort. You always want someone to have insight and take care of themselves. But Josh, it says, what recommendations do you have for resources before this last resort of having to file a petition to get someone civilly committed?
Yeah, and I agree. It's one of the most invasive things that somebody can do. And so as far as legal mechanisms, what we try to do at our office is create powers of attorney that would go into effect when the person got sick. So, one interesting thing about mental illness is kind of there's an ebb and a flow. In guardianship court, if somebody has severe Alzheimer's, it's a degenerative disease and they don't get better. And so if they need a guardian, they're always going to need a guardian. If somebody has Down syndrome and they need a guardian, they're not going to improve from that condition. They'll always need a guardian. Mental health and substance abuse conditions are very different. They're up and down. And so creating a power of attorney when you're doing well that says, if I get symptomatic in this way, I have a decision maker in place, then that's a way that the person has autonomy. They get to make the decision. Rights aren't being taken away. But then in that document, if you create a mental health power of attorney, the person can put the agent or put the principal into a hospital. So that's one legal intervention that can be implemented before you take away rights. Then I think that having good advocacy with the treatment providers is really important. What I find is, unfortunately, you've got to poke and prod. If we're talking about the SMI system, to get people to take note of your case, for them to care for them, to spend time with you, you have to really poke and prod them. And part of that process is the case manager or the doctor doing motivational interviewing, trying to get them engaged, trying to build a treatment plan that they're actually going to benefit from, maybe be interested in. And so the people around them trying to build a care plan that makes sense, I think is probably the best first step. Now, the problem with that is oftentimes the people who might need to be civilly committed don't want their families involved. They don't want the treatment. But when they're doing well, I think that's something to press for. And as ACME, we always are fighting for that, is for the teams to take a different tact and do things more person-centered than program-centered, and do whatever they can to make sure the services are necessary to get this person engaged. So I would say those two things are, there's a legal intervention there, and then there's a practical clinical treatment intervention there that I think can help prevent somebody having to go through Title 36.
Now, the second question from this person is a question: don't the two evaluating psychiatrists in the imminent danger order often check off the last two criteria, PAD, gravely disabled, and the DTO, DTS? For them, I'm pretty sure hers did.
Yeah, so when you go to file those applications, there's 4 boxes, even for PA, for the A form, which is non-emergent, there's danger, self-danger to others. So things like that don't make sense. But typically you should check all 4 just in case. That does happen a lot, where the psychiatrist will check all the boxes. When it comes down to it, the court is going to decide if the evidentiary burden has been met. And so that kind of gets filtered out at the court hearing. The judge is going to be able to decide, is there enough evidence for danger to self, or is this a PAD? So yeah, that is true, but I'm not sure that in the end it makes that big of a difference.
And we have another: if a guardian has level 1 mental health authority and the ward does not want to go involuntarily, which court do they need to go to, or do they need to go through the petition process at UPC?
Yeah, good question. That's difficult. So guardianship with mental health authority gives you the ability to do that one thing, which is admit to a level 1 facility and then make decisions once the person's in there. A regular guardianship covers everything else. The problem is that the guardianship doesn't have the teeth necessary to take the person from their apartment, for example, and bring them to the hospital. And so civil commitment does have the teeth. What I've started to do lately is in my orders from the court, ask them to put language in there that says police fire can transport on the directive of the guardian to a behavioral health hospital. Sometimes I'm specific about it, sometimes I'm more general about it. That sometimes increases the likelihood. Certain police departments are more likely than others to do that, but it's hard to get done. The other thing that I'll do sometimes is get an ambulance company to do it if there's just a guardianship, but that can be expensive and hard. If those things are not available, unfortunately, what's left is the civil commitment process. And so if there's not an order directing and you don't have some kind of relationship with the police department and have talked it through to start, then you're probably going to have to petition for involuntary treatment.
And here's another question on the POA, power of attorney. They've been told that because the power of attorney are out of state, they basically can't do anything. Is that true? Does the power of attorney need to be in the state to have that power of attorney acted upon?
No. So we operate under a uniform law, which most states operate under for those kinds of documents, which says if a power of attorney is valid in the state that it was created in, it was executed in a valid way, then it's a valid document in Arizona. And so, no, that's not true. Powers of attorney from other states should work here. Now, the difference is that we have, just like we have level 1 authority in a guardianship, we have a mental health power of attorney which does the same thing. And so if the out-of-state document doesn't have specific language about admission to a level 1 hospital, then that piece is missing. And so an Arizona document might be better. But generally, a power of attorney for everything other than admission to a hospital is going to be fine and is valid if it was validly created in the other state.
Okay. Another question. On the form, what do you say and what shouldn't you say on the forms? I know, as an example, when you get so frustrated when they will let your person out of evaluation because they test positive for drugs or because they say they are voluntary, they really will take their meds even though they haven't for months. Sometimes you might want to tend to exaggerate. So what's that fine line between trying to give enough information and paint a true picture to where they won't immediately dismiss someone if they're co-occurring?
Yeah. If you're meeting with me in person, I might have a little more straightforward of an answer, but you have to look for the weaknesses in your petition and be able to fill in the gaps. So, for example, if the person is saying they're voluntary, you should know that, and you need to put in a history of when they've refused treatment and when they've told the doctors they're voluntary and then they don't follow through. Because the statute doesn't say that the person is unwilling, or is, if they're willing, they can't be court ordered. What it says is willing or unable. And so they might be telling you that they're willing, but based upon their history, they're unable. And so I guess it's easier for people that have been through the process and been rejected to know where the holes in their applications are, and then you got to try to fill that gap. And you can call me and ask me those questions, and I can help out with that real quick. But that's the key, is to kind of understand the holes and then try to provide as much information or history as necessary to fill the gaps. If you had more specific scenarios, I could provide examples, but that's the key, is providing that information. On the emergent petitions, it's describing very well the harm the imminent harm. On the PAD, again, it's the severe harm, and the way you describe it, that is the most key.
We had someone, David Klein, say he uses substance use as a secondary to mental health disorder, and it seems to work for his petitions. So putting it right out there, like you said, also telling them, I know they're going to be positive for this, but kind of explaining it.
Yeah, I think that's the way to do it, is to confront it at the beginning, because you can at least have a conversation. When you go in, if frontline staff isn't being cooperative and they're telling you no, that he tested positive, I would ask to talk to a supervisor and explain that does not preclude him, and this is why. And they will reevaluate.
And we have another question. What language in a power of attorney makes it become active in the case of mental illness? I have found that doctors do not want to claim a person is incapacitated, so they would not allow the POA to be effective.
Yeah. So that's one of the big problems with powers of attorney, is when are they effective, and revocation. So a person can revoke power of attorney at any time that they can provide informed consent. That happens a lot. It makes them very, very flimsy documents because they can revoke. And they always revoke at the time that the power of attorney needs to be used. Also, the situation that you described, when is it effective? That's really difficult to do on the fly, and doctors and healthcare providers don't like to jump into those kind of legal issues. And so the tips there are to create language that says this is effective immediately, right now as I'm signing, and to create language within the power of attorney that says this can be revoked when I provide when I'm able to give informed consent, and it's verified by a doctor's note which is attached to this revocation. That flips it on its head and puts the burden on the principal to go out and be able to revoke it. So you got to cure those things. And again, that's nothing you're forcing on the person signing the document. They choose that language. They look at that language. They know that it's there. And if I were in that situation, that's what I would want. I don't want, at the time that I can't make decisions about my healthcare, to be out of my mind and then revoke my power of attorney. So there's ways to cure that, but without those things, they really don't work in the mental health context.
Okay. We have some other comments by a psychiatrist that said it was, even for her, after many, many years practicing, they thought it was great information, and they were very happy to attend. So.
Oh, good. Okay. Well, I think we went through a bunch of questions. That's the presentation. We'll put this on Acme's website. So
I think the last slide, though, Josh, has some, the next, after the questions, we had some potential comments from upcoming educational meetings. These are things that we've heard of, but if you have other items that you'd like us to have experts present on, you could just either type them in the chat, or you could send us an email to let us know.
Yeah.
Also, another comment, amazing presentation. Thank you very much. This is so helpful.
Oh, good. Okay. Well, we're planning on doing these maybe once a month. The next one is going to be on when your child gets arrested. That happens so commonly. I get calls like that all the time. But Holly Giesel is going to be doing that. She's amazing. But we would like topics. We would like to know what it is that you guys would like help with, so that we could do some presentations on it. But it's good to hear that this was helpful.
Okay.
Okay.
You're getting a lot of comments and a lot of people thanking you for the great information. Awesome information. Duty to warn would be a topic.
That's a good topic. Okay.
Yeah.
Okay.
Yes.
All right. Well, I think that's it. Unless there's some other question, Laura. I think we got it whipped.
Okay, well, thank you, Josh, and we'll figure this out. I think the whole polling thing was due to multiple logins with the same link. A copy of the slides will be loaded up on our website, and we'll probably put the video on there as well. We also plan to put maybe some templates on, you know, a spreadsheet of what to track, like Josh demonstrated, and also maybe some petition examples of what you would say that would be more likely, if, you know, how to fill them in. Obviously, you don't copy the behaviors, but just an example of where you would put information that really needs to be communicated.
Right. Right. Okay. All right. Well, thank you very much, everyone, for attending. We appreciate it.
Thank you, Josh.
Okay. Bye-bye.